Welcome to another episode of the X-Files, the divorce and separation podcast with me, Alex Wynn, family lawyer, and my esteemed colleague and friend, Liza Friedwald, also family lawyer, mediator, and a few other things besides.
Yes, excellent. Good morning.
Today we will talk about costs in family law cases generally, and that's not just cases before the court, but it's the whole gamut. I think where Liza and I, where we benefit from a client's perspective, is that we see a case from cradle to grave, rather than, somebody who does a little bit of the mediation at the beginning, perhaps, or maybe the barrister that does the final hearing, or the judge that makes a decision. They see small sections of where the case goes. So we thought we would cover the whole thing from cradle to grave to see where costs get bigger than they should be, how you can contain those, what to watch out for, maybe a few pitfalls, and perhaps to some extent what the law says. We might even, as lawyers, talk a little bit about the law, but we're not going to go.
No. Don't
Sections,
spoil
no
a good
cases,
episode with talking
none
about
of
the
that.
law. Come on.
If you need us to go through sections and cases, then you probably need to come and approach us and engage us as advisors. This is just for information only. Please bear that in mind. This is not to be taken as legal advice. If you're going through something, reach out to either of us and we'll be able to represent you, conflicts permitting, or find your own family lawyer and get proper advice for your situation. So, forgive the reading glasses today. I don't know why I put my lenses in, but I did. Right. So
first of all, we're looking at why the costs escalate in the first place.
yeah. So, let's even roll that back a little bit, because there's a lot of horror stories about costs in family law, and there's a reason that there are horror stories out there.
What's the worst one that you've had? What's the highest amount of legal costs that you've come across? And not necessarily that you've charged, but in terms of the clients come to you.
Almost $500,000 on what was, I thought, a straightforward enough parenting and a little bit of property thrown in. Almost $500,000 charged by the other party to somebody. I was astounded. Absolutely astounded. There were changes of counsel, that's barristers. There were interlocutory applications, but in my view probably did not need to be made. This kind of overlapped the period when things changed a little bit in 2021. So it was a little bit before, a little bit after that. But broadly speaking, somebody threw away the better part of $500,000 on an outcome that really...
That's just one side, isn't it? That's just one side. That's not the other side's cost.
No, that's right. So and we are, you and I are very, I think, diligent. We're very careful to be proportionate with what the charges are. You don't put so much time into a case. If you're arguing about $500,000 of a property pool, you certainly shouldn't allow the lawyers to be spending all of that on the pool. When I first came to Southeast Queensland, well, a long time ago now, but there was a firm that they're not around anymore, but I won't give names out anyway. And I remember taking over a case from that firm, and it was right at the point where my client had effectively run out of money, and I'm just working in sole practice, so I'm doing it not out of love, but out of interest and fairly reduced fees, just to help somebody out to finish something. But I couldn't believe how much money had been stripped out of the property pool.
I've seen that quite a fair bit. And also in recent times, what I'm finding at the moment is people running out of money. They get close to a trial, there's trial directions made, and they might have spent almost, a couple of $100,000 in legal fees already, and they haven't even done their trial affidavits. So that's a worrying trend for me, and where I think that there needs to be a little bit of action by everyone involved in the process. But I think for the most part, as a party to a case, you actually have that power to try and control what those costs are and how they escalate and how they are to remain manageable, so that you can see the whole case all the way through to the end. Because there's no point you spend all your money having these silly letters going backward and forward, and as it turns out, you've got nothing for when it really counts, and then you end up with a half-rate barrister or really badly drafted affidavits that you've had to do yourself, or, God forbid, use ChatGPT for. So,
we'll talk about that later. But you're absolutely right. I mean, it's always important to be proportional about what you're going to spend on something. It's a bit like going out and buying a car, I suppose, isn't it? If you're going out and you're going to go and buy, I don't know, a Toyota Corolla or something like that, and you go into the garage and they're trying to sell you that car with gold plated wheels and and triple turbos and everything is made out of rhino leather inside. That's probably disproportionate. The family law case is not so very different from that. It's like any other purchase. Probably the first thing you need to do, if you're having to think about, right, we've separated, we need to get to an end place where we can go on and live our lives, where we've sorted out our property and we've worked out arrangements for the kids. We can't agree about everything. So there's going to be some push back and a little bit of forward. And that's going to cost me in lawyers and maybe mediators and possibly court fees. So thinking about where you want this to end, what's your outcome, what are you shopping for, is a good way of starting this. So maybe think about, well, what is it that we are fighting for? How much money is at stake? What can we agree upon? And we'll talk a little bit about settlements as well, and why you have to sometimes take the emotion out of that, and that settling for something which might seem to be a little bit less than you think you deserve is sometimes a much better financial choice than going through a court case where you're spending, as you say, possibly six figures or more. So why do costs escalate? That was the question, wasn't it? So, well, you've mentioned the correspondence, the dreaded litigation by correspondence. What do you mean by that?
When you get some lawyers like to write long letters, and I say a long letter is something more than about 3 pages. Ideally, I
Got to
always
see a
think,
penny on the other day, but it was a very complicated matter.
well, I do sometimes as well, but it has to be for the right occasion. But you find that there are lawyers out there who will write like 8-page letters, which I call poison pen letters. And if your lawyer is doing that, ask them why.
Mm.
Why do you need to set this out? And why do you need to set these things out in such a way that's not necessarily going to be helpful for the other party to think, oh, okay, well, actually, you're right. I might take you up on that offer, or I agree with you on that point. If you are on the side who's just writing attacking letters for no real purpose, that's not going to achieve anything, ask yourself, first of all, why, and then think, how much did that just cost me?
Mm.
I can guarantee you it's going to be a lot of money, a lot more money than you think. And especially if you've had involvement in that letter, because you might be feeling a bit emotional, you might be feeling a bit bitter about the whole case, about what's happened, and you feel like you need to get this off your chest. And you've gone backwards and forwards with your lawyer saying, oh no, I want you to say this and I want to take that paragraph out. And then you've run it through ChatGPT, and then you've said, oh, how good is this letter? Is it good or is it not good? And then you've told your lawyer, oh, I really need you to cover all these other things, which you think or ChatGPT thinks is really relevant, but it's not. And
No.
so you've then turned one exercise of one letter into probably 6 hours of work. And if you multiply that by your lawyer's hourly rate, it could be many thousands of dollars just for one letter.
Yeah, and totally unnecessary. And particularly if you've got a solicitor on the other side, a lawyer on the other side. I really don't need to hear a 12-page letter citing every case and rehearsing every section. That's our job. We know this stuff. We
We
don't
should
need
do.
to hear it. Well, we should do. But it seems to me, and I know that we've said this on a fair few episodes, that the longer the letter and the more technical the information, the less likely it is to be effective. You need to get to what is the dispute here? What are we actually trying to resolve? And it's fine for everybody to have a different perspective on something. If we can at least narrow the issues rather than expanding it out into, 10 and 12-page bullet point numbers and, numerical, alphanumerical sort of listings throughout this and demanding responses. As soon as I see headings, I'm going, oh, here we go. It's
Yep.
this is going to cost a lot of money, and you have to warn your client. Sometimes it's best for us to, I'm not going to burst into the Ronan Keating song again. Sometimes it's best if we say nothing at all. It's
That's
just
going to be your mantra.
maybe so, but it's good advice if you want to keep your costs down. Think about what it is that you're squabbling about. And you don't need your lawyer to become Leo Tolstoy. Nobody is looking for another edition of War and Peace. It's
No.
a turgid enough read as it is, and you don't need it starting with a letterhead from Sue Graviton Run Solicitors. So, instructions to your lawyers then. That's very important. Think about what it is you're asking them to do beforehand, because if you're saying, I want you to complain about this, all of these things in the relationship, well, it's really not the forum for that. The best advice I've got for you there is to go and have a chat with a friend in a pub, get those things off your chest, and then think, what am I trying to actually sort out in the land of the law? It's
Uh,
money or it's
yeah.
children.
Well, that's right. And, sometimes these aren't necessarily legal questions we get asked.
No.
It's how do I send this text message, or what should I do here? Oh, I don't know. I'm not going
Yeah.
to tell you what you can and can't do with your own children.
A
And
little
so there,
caveat with that is
those
if you're
things.
going through a proceeding, you might want to run through a text
Well,
if
it
you.
depends on the type. If
Oh,
it's something a bit outlandish, of course. Like
yeah.
if you're if you're thinking that you might want to send your 6-year-old to a hard metal concert or something with lots of swearing and scary looking people, probably not. But I still don't think you need your lawyer to be asking and answering those sorts of questions.
Common
So,
sense is still allowed, isn't it?
yeah. So think about what it is that you're asking. Alex has made a very good point. Sometimes there's differences. There's a
I'll write
different
that
type of
down.
advice
Liza said Alex made a good point.
once.
Oh, what's my diary?
It's very rare. But anyway, no, it's rare that I admit it. It's not that it's rare that that happens. I'm pretty sure it happens more often than I will admit. Um, but in any event, you have the situation where you are often bombarding your lawyer. And I say that in the nicest way possible, but realistically, a lot of the stuff that comes in is not seeking actual legal advice. And your mate down the pub would probably be the best person to be able to help you because, first of all, they know you, they probably know the other party, they probably know your kid, or whatever the dynamic is. They know much more of the history than what we would. So think about what it is that you're asking before you actually ask the question, because that can really cause your cost to escalate.
Another,
There's a, yeah.
go on, sorry. I
Oh,
was going
sorry, you
to
go.
talk about things that you're asking and providing to your lawyer. That brings up one of the thorniest issues that we ever deal with, really, which is the disclosure point.
Oh,
Now,
God. Yeah.
that's where costs can be thrown away at
Mm,
something which is, I think, relatively simple. It's simple, but sometimes not very easy to collate your financial documents. But it's very important you do it, and it's best that you do it on your own, or with the help of your admin, or if you're accountant, if you've got an accountant. Put that together as a package for your lawyer, right? If you send through dribs and drabs and things, oh, here's a tax return from 5 years ago, and then 5 days later, oh, and here's one from 3 years ago, oh, and here's 500 bank statements. If you collate it and organize it, then your lawyer will not have to do that. We'll still need to check through it to make sure that what we're saying in advance of your case, to put your case forward, is right, and that we've got something to rely upon it. But the better organized you are with the documents you send to your lawyer, the lower your legal fees ought to be. I mean, if they're not, can you give
because
us
we're
a
not
clue what's going on?
we're not like accountants. Accountants, you could just give them a shoebox and they somehow, so it doesn't seem to add to the costs of your bill a lot of the time. I know I'm really bad with my accountant. It's, here you go, have this. Um,
Random pieces of paper,
Random documents, random
that's right.
dockets with little scribbles all over it. Um, us lawyers will charge for that. And
Well,
because it
because
takes a
we
considerable
literally
amount of
have to
time.
look at it. If you send it through to us and it's undescribed or it's unbatched and it's undocumented, then we'll go, well, what is this? Where does this fit into the jigsaw puzzle of this case? And it can waste a lot of money. But if you collate things, I mean, most of your family lawyers, Liza and I will send to our clients like a shopping list. We would like all of this financial information, please. And we don't just sort of invent that. It's pulled from the court rules. So we're not trying to be difficult. We're saying, please, can you give us as much of this information as you've got? We then get that, and we ask the other side to put that together as well. And then there should be a nice, efficient exchange of disclosure documents so that everybody knows what we're dealing with, that
Yeah.
there's no hidden things.
Mm.
But
What
if
I
it
like
comes
to do
piecemeal
also,
and it's
mm,
just difficult. Go on.
yeah, what I like to do is when parties are fairly amicable, in order to keep the costs down, if you guys have performed that process yourselves, and my role is not so much to be in your case 24/7. My role is to advise you and to say, look, this is what you're going to need. This is where the ranges fit. but you're going to go off and do your own negotiations with the other party. And a lot of people do that these days, and there's nothing wrong with that. What I like to do is I like to give you your shopping list, say, here you go. I will give you some guidance with that collating of the documents and getting all nice and packaged nicely if you need that help. But ideally, that comes to me, and then we put it all together, and so that you've got a big package of information from both the other side and your side, and then the two of you can sit down together, if you're amicable, and go through it and say, okay, right, I can see that this all makes sense. I can see this is where the money has gone over the years, and this is, this is what you're earning now, da 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 da, and we're all happy with it. And you don't always need your lawyer to actually look through and scrutinise those records.
Thousands of entries on bank statements. It's going to cost you a lot of money.
It will.
Is it really relevant? But look, that segues us into like the next possible thing we should be talking about, which is how do legal costs get incurred? There's different ways in which lawyers and people involved in the whole family law process charge. Traditionally, and probably still predominantly, it's the hourly rate. So it's basically how much time is spent on your court case or your legal case will determine how big your bill is. Obviously, the longer it takes to do, the more money it will cost because you're paying a professional. You mentioned it's usually hundreds of dollars an hour for a lawyer to spend time working on your case. So the smaller that you can make the issues, the narrower the issues, the more discrete the questions, then the lower your bill should be.
And
There are other ways outside of hourly rates, though. And you talked then a little bit about doing sort of a scoped piece of advice or a scoped piece of work.
The way I operate these days, I've moved beyond just plain hourly rate. Hourly rate will work for certain cases where you don't have that level of knowledge of where the case is going to go. But in a lot of cases where parties are amicable or it's early stages and people don't necessarily want to spend all that money at the early stages of the case, they would prefer to reserve something for a trial if they need to get to that point. What I would do in a lot of cases, I either offer like a cap fee package. I don't do fixed fees only because I think fixed fees, if I end up doing it in less time, then I'd like you to have the benefit of that cheaper price rather than it being a fixed fee. You might get me to draft a consent order, and in your case, it might only take me 2 hours of time. So I think that the client should have the benefit of that reduced fee. There are different methods and bases upon which people will charge. Be very careful with the fixed fee arrangements and people say that they offer, because a lot of the time it's only for specific jobs and specific works, and it's a number of revisions and amendments to the work. So it might be, as I said about this letter, you might say, well, I've got this package and they're going to do fixed fees for a period, like a fixed fee of say 2 months, and that's how much it's going to cost. And in that package, I get a letter and I get this and I get that. And on that letter, you might make 16 different, and I'm not talking about number within the same letter. There might be 16 emails going back and forth, and that your lawyer might turn around and say, well, hang on a minute, I'm okay with 2 emails going back and forth, and after that, that's all hourly rate stuff. So be very careful that you've read the paperwork very carefully when you are entering into any of those package style options. I'm usually pretty clear with my packages. I don't muck about. I'm there for a particular task. Otherwise, I'm on hourly rate, and I make it very clear to people.
It's sometimes then easier if you understand the lay of the land from the first consultations that you might have, and then you get that tranche of information. So once we as family lawyers understand the case better and where it's likely to go, we can then scope out, well, the rough cost we would normally expect is going to be in this range, and so we can prepare a disclosure around that. And then it might be up to a person to say, look, I can't afford all of that, but what if I do some of the work myself? And that's fine. I think so long as they understand that we'll be coming into the case on a limited basis.
Yeah.
And that sometimes that means we can only give qualified advice if we don't have the whole picture. That's fine too. So as you said, if a couple can work things out relatively amicably, that doesn't mean you have to be friends, but you just agree with what's going to happen. your costs will be dramatically reduced. If, on the other hand, um, the other person engages a particularly contentious, cantankerous, contrarian lawyer on the other side, or that's who their personality is, and so they're drawn to that, then the conflict could see your costs rise. And that's where it's important that you're clearly communicating with your lawyer, saying, look, you just acknowledge the letters and say, we'll go back to that later if we need to, rather than, as you say, picking upon every single squabble. That's not important. It's focusing upon the relevance that gets to be big. Now, what have I got else here? Ah, yes. If you're in the court process, the procedural parts are very important to follow. Now, I mentioned, the 2021 changes, and one of the things in that was this behemoth of a central practice direction that we've had the pleasure of talking about before. And it introduced a raft of interim stages and things you have to do and more forms, all amusingly entitled with a start saying, we're trying to keep this more inexpensive and cheaper. And it's very hard to do if you're adding in layers of extra things to do. But nonetheless, when you're going through your case, if you don't want to be even potentially staring down the barrel of cost orders against you, then make sure that you comply so far as you possibly can with the directions that you get from the court, with the orders about things to be done on certain days. Make sure that you stick within the rules, so financial disclosure and what you're supposed to do, when you're supposed to do things. So procedurally, you can make things easier. And of course, if you are representing yourself or in whole or in part, then keeping a proper note of when things need to be done by planning them and doing them in good time. It's more work for you at that point, but it'll save you costs down the track and
So
avoid that risk.
I also take from that, though, Alex, is that if you are not self-repping and you have a lawyer, your lawyer should, at the early stage of your matter, particularly if it's in a court, if you're already in that court proceeding stage, have gone through that central practice direction with you, or at least given you a copy of it. That document is really, really useful to work out a budget for you in terms of your costs. Because at that point, you're in the court system and there's some compulsory things that you're going to have to comply with. So this is not a case of, oh, okay, well, I'm going to pick my battles. I'm not going to respond to that correspondence because it's not very helpful. You can't do that with the court. Oh, I'm sorry, I'm not going to file that financial statement because I don't really think that the cost is worth it at this stage. You're just going to have to do it. And guess what? You're going to have to pay your lawyer to do it. So you need to sit down and work out exactly how much you're going to need to budget for each of those stages and each of those steps. Use the central practice direction because it gives a great guide of what you're meant to do. Of course, bonus points if you don't actually have to go through with one of those steps or many of those steps. They might be talking about dispute resolution and you may not have to do that. Well, great. So you've saved yourself some more money. But in terms of working out a budget and how much money you're going to need for a court process, use that. Compare it as against your costs agreement that you would have received, your cost disclosure notices and stuff from your lawyer. If your lawyer hasn't set out how much of these things are going to cost in there and broken that down, ask them. They can tell you, and they should know how much it's going to cost roughly to prepare a response to an initiating application.
It's a really good point, actually. I saw from a very big firm, actually. I mean, one of the sort of so-called top tier firms that was dabbling around in family law. The costs notice, it just had just a big chunky number with no explanation as to how they got to that point. And we were talking. It was a relatively late stage of the case. It's going to be another $90,000. That's it. And I looked at it,
how?
having done my own to my
what?
clients, saying, these are the things that are going to be happening, da 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 da. And it was about a third of what they said, and it was detailed. I'm baffled by that. So you should query that with your lawyer and say, hey, can you just give me some stage by stage understanding so I can prepare my budget? Because, I mean, I don't know where some of the firms get those ideas from, but I haven't met a client yet that's got a money tree in their back garden. There is a finite resource as to where.
If you know someone, send them our way.
Yes,
happy
please,
for that. Happy for that one.
If you know a gardener who has got some seeds for a money tree, I'd be delighted. no doubt there'll be some kind of crypto person that's just looking at this. Oh, there's a couple of likely options. So, I mean, people get money to pay for legal fees from. I mean, coming on to the query that
Yeah, the litigation funding and stuff like that.
litigation thing. So, but the primary areas are from your savings,
Yep.
from potentially equity that you might have in a property. That could be the family home where both of you are having to draw
Like a
on that,
mortgage and
like a mortgage or
redraw.
a redraw or something like that. Maybe you go to the bank and get a loan. Maybe you use your credit cards as far as you can if you've got sufficient space on those. Maybe you get family and friends to help you out.
Some
But you
generous
do,
friends.
it's been known.
Yep.
It's some very generous friends in some cases that we've dealt with.
Mm.
Um, but increasingly, we're seeing litigation lenders specializing in family law coming into this space as well, so that a person can borrow from a dedicated lender who just works in this field. They don't just, it's not cars and boats and houses. It's just, it will lend you the money that you need to pay your legal fees, often including your expert's fees or your barrister's fees,
Yeah.
enough so that you can get your trial finished and get a judgment, because your case is one where you're going to receive a lot more than you're going to spend. And so it's less risky for them. But I mean, what are the pros and the cons of those? Oh, bear in mind, this is not financial advice. This is just us
No.
as a couple of.
So the litigation lending, that's been around for quite some time, but it's becoming more and more prominent in the family law space, mainly because parties cannot necessarily afford to pay lawyers from their own savings. One of the benefits and one of the differences between getting funding from a litigation funder is that you'll have the ability to pay it at the end, versus if you go and get a personal loan or if you redraw on your mortgage, you need to have cash flow in order to pay that back. A lot of the time in a family law dispute, you don't have the cash flow at that point. One party may be controlling all the funds, and if that's happening, then you're not going to be able to afford a personal loan or having to make those payments. So one of the benefits, and I think that the most attractive thing in relation to litigation funding, is that it just comes out at the end. So they can either get the funding and put the chunk of that money into the lawyer's trust account for them to pay as they need to. The other alternative is that the lawyer will send the bill to you to make sure that you approve it. And once you've approved, it gets forwarded on to the funder to then pay our bill. And so that gets paid, it includes the disbursements, so counsel fees, mediation fees, experts fees, things like that. That's all included. So you don't have to have that worry of being restricted in your approach and your preparation to a case. But there is a big downside, and that is the interest rates that are usually a lot higher than what you would normally get for your personal loans and your mortgages. So before you go down that path of litigation funding, I always recommend that people talk it over with either a broker or their accountant or a financial planner. Talk
Yeah,
about the
maybe other options out there for
yeah,
you that are cheaper, certainly in finance,
that's
in
right.
interest rate charges and so on. Super is generally not available for funding in litigation cases.
No,
I mean, everything turns on its own, but it's not one of the criteria that's usually permissible to draw down out of your super. Obviously, if you're already at an age when you can draw on your super anyway, then it's just a
then it's
resource for
different.
you.
Yep.
It's different. But I'm thinking about people within the working stages of their lives. It's not available to you, so you'll have the equity in maybe the matrimonial home that both of you may be able to draw down on to squabble with one another. So again, coming back to like fundamentally the best way to save money on legal costs is not to get into a massive legal stash where you can identify exactly what are the areas of dispute between you and your ex, negotiate either through lawyers or use a mediator, and try and come to an early settlement, because otherwise you might both be pulling money out of the pool. And we see this all of the time, the property pool, that is, rather than the pool in the backyard that's going to have to be sold in the house. But that comes away from both of you. And if you've got children, ultimately it comes away from your ability in the future to buy and do things for them too.
Yeah.
So,
But just before we leave that with the litigation funding, is that they will want some sort of security. So
yeah,
a lot of the time it will only be available to people who have property. It's very difficult if you are not the owner, if your name's not on title So there may have to be some other avenues you need to explore before you can simply just go down that litigation funding path. But talk to your lawyer about it and make sure that they're accredited with the main litigation funders. It's just an extra option for you in addition to those other
Yeah,
avenues that we've discussed. But
there
there's
are
also the court application too, Alex.
you've jumped ahead. I was just
Oh,
looking at
have I?
my
Excellent.
scribbly yellow pad, thinking the next thing we should be talking about probably is, well, what if one of you does, sit on all of the assets and the other one needs the money to be able to bring the case and to finish the case off, and your ex is just covering the rears, going, "Go away! I'm not giving you a red cent. Off you go."
Yep.
That's when you might need the help of the court to release some money from the screaming, squabbling ex-partner and say, "No, no, you're going to pay your wife's costs." And there's a couple of ways of doing that, or your husband's costs. There's a couple of ways of doing that, I suppose. You've got interim payments. Here's a chunk of money, and we might even call this a partial property settlement, and you can spend it on what you like. That might include your legal fees. Or I think it was in that multi-million dollar case of Strahan and Strahan that they had those dollar for dollar costs orders. So you ended up with a court saying, well, for every dollar the husband spends in this multi-million dollar claim, the wife gets to spend the same with her lawyers. Now, that's, dare I say it from a lawyer's perspective, it's not that hard to resist that if you're, the respondent to that application, if you can be creative about where your client's going to pay their fees from. So in other words, your client is not actually paying you dollars along the way, then their ex's lawyers may say, well, because there's nothing to come to them, there's nothing coming to us. But cost orders can be a very effective way of releasing, some money to the person that doesn't have control of assets or liquidity. And probably the first thing that you would do is you don't jump straight off to court and ask for that. You simply ask for it. You say, hey, look, rather than us having to go through, the hoops of getting a judge to decide, after we've probably spent many thousands of dollars to pose the question, it's only fair that I should get X dollars so that I can cover my costs because you're covering yours. And if they disagree, you might even get
You run off.
you get another costs order against them for refusing to give you the money that they probably should have.
Do you know, I usually look at it in terms of how much money is the other side wanting. So, for example, if the other side is wanting $100,000, you might think, okay, I'll resist that. That's worth having a fight about. Okay, you may have your own reasons. You may not believe that they're actually going to use that. They might just put it all on black. You might be very concerned about that release of those funds. The other alternative, of course, is they might say, oh, we only really want $10,000. We just need $10,000 to put towards our legal fees or something. If it's something that's a small amount like that, you're going to spend more than $10,000 fighting that $10,000 application. So again, think about the proportionality of these costs in terms of how much is it actually going to cost you to get to where you want to be. It's going to cost you more than $10,000, more than likely, to resist an application to pay the other side $10,000. And in that situation, a lot of the time, it's often a case that it's the characterization of that release that is the dispute, because you might say, oh, well, it can be treated as a partial property settlement, and the other side says, no, it's not to be treated like that. So the sensible thing to do at that point is to say, well, it's to be characterized as an issue for the trial if that's where you're headed. You can characterize it however you want along the way if you both agree, but you can save that issue for the trial.
Yeah, I think the courts have to discern which power it's acting on to be able to release the money, but it doesn't have to define it.
That's right.
So lawyer double speak there, but just to make sure there's an identifiable power for the court in order to be able to make that order as to what it's going to. So you'd have to have some entitlement, in other words. If you're bringing a court case to say, I want them to cover my legal fees, then one of the considerations of that court, of that judge at that time is going to be, I'm looking into the future a little bit, and what I can see here is you'll definitely be getting a property settlement. And if you will, then you've got a good prospects of getting that order. On the other hand, if yours is a very speculative claim, then you might not get very far with that, and you'll have spent a lot of money to get to it. Now, on the subject of costs, I'm mindful of the time, but there is one thing that we probably want to touch on before we wrap up, which is at the end of a case, the usual rule is that you pay your costs and they pay their costs. That's the usual rule. And section numbers have changed. I'm sorry, I said we weren't going to talk about
There
section.
are. Oh, yeah.
Who cares? The
I
point
get
is,
confused.
if you make
It's in
an
the
offer
Act.
to somebody and you do it in the right way, and then you are compliant with the rules and the directions and your disclosure, so you continue to be well behaved within the court's framework. If that offer turns out to have been a really good offer that they should have accepted a long time ago, that opens up a change in the ability of the court to really consider, I'm going to make them pay some or most of your costs from the point that they should have accepted that very good offer. Now, you'd need to make sure that it's framed at the right time and in the right way, and that everything else is fully compliant to be able to run that. But that is a way of trying to bring things to a head with a settlement earlier by making everybody really clear that the costs aren't just necessarily going to stay with each party. That you not only are you going to have to pay a settlement to your ex, but if you've been a bit of a fool about it and you've turned down a good offer, you might have to pay that cost from that. And there was one that came out of the Sydney registry only last year, and it was a husband had turned down a wife's perfectly good offer, and I think he got whacked with $174,000 worth of her costs as well. So be mindful of that and talk to your lawyer about what's the right stage to make an offer. If we're getting nothing, then at least you put that line in the sand there, and it might help bring your overall costs down at the end of the day.
Well, the general rule I follow in terms of when to make offers is, when are you ready and willing and able to walk away from this matter? When do you feel comfortable that you could put forward an offer? And it doesn't necessarily have to be at any prescripted time. Ideally, it is after both parties have exchanged disclosure, so that you both understand that the case that you're running, you've got some idea of the evidence from the other side. So whether it be through disclosure documents or affidavits, and that's probably the best time to actually put forward those offers, trying to secure your costs,
I did that
because that's
just the other day on a case that isn't even before the courts yet because we'd completed a fairly decent exchange of disclosure. That the information was pretty well agreed, so I knew what the lay of the land was.
yeah.
Put forward a very detailed and I think very generous offer, and then I made that subject to the rules and future
I
squabbles
always
about
like to do it straight after a mediation too.
keep those going. Concentrates the mind, doesn't it? People have walked away from mediation going, oh, well, that didn't work. And then
Yep.
a settlement offer arrives the next day going, this isn't going anywhere. I've got to take this seriously.
Yep.
And we do see that quite a lot, don't we? A mediation that doesn't settle on the day settles, in the days and weeks
Yeah.
following because you keep that pot on the stove, so to speak. You send those offers and you're constantly honing the case down. All of those things help to keep people's costs down. So I think we've probably talked ourselves to death over some costs for today. So thank you for listening, watching, following, and give it a like, give it a click. Do the things that people do on socials.
Yeah.
And if you have any questions, like
Subscribe.
Alyssa
Something.
say, please just send those through to us, and we'll incorporate them into a future episode.
Okay, great. Thanks for listening and watching, guys.
Thanks. Bye.
Bye.